Welcome, welcome to our conference on law and belonging. It's nice to see a lot of friends who will be celebrating with us a small anniversary of our chair. And when we discussed this event, at first we thought perhaps we would focus on some ongoing projects that we've been doing on environmental governance, on the energy transition and climate change. But we also realized that this would be focusing too much on ourselves, and we wanted to create some space to invite others to think with us, to learn with us, pressing concerns that go beyond our current priorities. And we landed on law and belonging. And I would like to welcome all of you to this conference where we look at a number of themes in law and belonging. I'm Thoko Kaime, and I am chair of African Legal Studies, and I would like to welcome you to this event on behalf of my colleagues who are here with me. And we hope that for the next couple of days, we have debates, we exchange on what law as a normative frame, law as legal artifacts, help us make sense of the places and the spaces that we find ourselves in the world. This might be in the context of human rights or environmental law, or even contracts. So I'm looking forward to the next couple of days where we have this debate. I see friends who've come from far and wide to be here. I'm grateful for your presence here. I will not make long speeches this afternoon, and I wanted to start by sketching what I think is an agenda for law and belonging. So let me begin with something that I consider a basic, but otherwise simple truth. A truism that is often lost in the bustle of important legal work. And it is this: law is not a set of abstract rules, but rather a living tapestry woven into the fabric of everyday life. Now, to a black letter lawyer, this is the ultimate blasphemy. But coming from me, I would like to think that it is actually anticipated blasphemy. Because my journey in the academy has been driven by a fascination with the law's legitimacy. So my scholarship in human rights and sustainability governance has taught me that the law's power lies not in statutes, but rather in how it shapes and is shaped by relationships and people's and communities' sense of belonging to particular legal orders. And today, I would like to propose that we re-examine belonging through the lens of a serious socio-legal critique, a framework that demands that we confront the law's entanglement with power, socioeconomic, religious, and cultural conditions, and the messy realities of human experience. So bear with me as I outline my case. First, belonging as a socio-legal construction. Now, belonging is not simply granted by legal texts or formal statutes. Rather, it is a dynamic process negotiated through what socio-legal scholars identify as legal consciousness, the ways communities and individual members of a society perceive experience and mobilize law in their everyday lives. Legal consciousness encompasses a set of ideas, views, feelings, and traditions that shape how people interpret legal norms and their place within them, reflecting a broader social structure or cultural meaning rather than merely formal rules. It is a social practice that both reflects and forms social realities, embedding law within lived experience and power relations. Moreover, legal consciousness is shaped by the social stratifications such as class, ethnicity, and gender, which influence how law is understood and mobilized. Different social positions produce divergent legal meanings and experiences, complicating the idea of a singular hegemonic legal order. This is spectacularly clear in contexts where plural legal orders coexist, with communal law and state law often in tension. So for instance, local mediators and community members often resist the dominance of state law to preserve customary inheritance practices, reflecting a struggle over legal authority and belonging that is deeply sociocultural as well as juridical. A sociolegal theory of law as a social system further complicates this entanglement. Law operates through a binary code of legal and illegal, maintaining its boundaries by producing expectations about what ought to occur. However, these expectations are constantly being negotiated and reinterpreted within the society's broader communicative systems, including other aspects such as morality and religion. This systemic view underscores that law's meaning and function are not fixed, but contingent on ongoing social processes and power relations. So, for example, in my research on energy poverty, legal frameworks designed to ensure renewable energy access often fail because they overlook how communities feel and relate to the law. When policies prioritize technical metrics over relational dignity and social recognition, they reduce belonging to a conditional transaction, rather than affirming it as a fundamental right woven with human dignity. This disconnect often undermines the effectiveness of legal interventions and marginalizes those who live those realities that do not align with the formal legal categories. There are other examples. Land tenure, for example, when we look at land tenure under African customary law, we find that access to land is structured by group belonging and social relations, not merely individual ownership. Community leaders, often regarded as custodians of ancestral traditions, allocate land and mediate disputes, reinforcing belonging through kinship and communal ties. The continuous struggle that is discernible from the coexistence of customary land tenure systems and the received law are indeed indicative of the struggle for belonging. The legitimacy of these leaders and the law itself is rooted, therefore, in their ability to maintain social harmony and uphold collective values, rather than strict adherence to statutory provisions. So if we take a relational approach to law, we appreciate that the legal disputes, such as those on succession or land allocation, are as much about asserting moral standing, identity, and one's sense of belonging as they are about resolving technical legal questions. It is clear, therefore, that belonging is a socio-legal construction that cannot be fully grasped through legal texts alone. It emerges from the lived experiences and cultural frameworks through which people engage with the law, and recognizing legal consciousness as a site of negotiation reveals the limits of formal law while highlighting the importance of relational, cultural, and moral dimensions in shaping legal meaning and social inclusion. Now, my second point, this is on law as relational infrastructure. So Sociological critique increasingly frames law as infrastructure, or to use some hipster language, the law is a relational tech that coordinates and contests the social material world. So law in this sense is not merely a set of rules, but a dynamic assemblage of norms, practices, institutions that allows us to mediate relationships amongst individuals, communities, and their environments, and in between these elements. And this perspective draws on the new materialist turn in legal scholarship, which recognizes law's embeddedness in social material networks and its capacity to shape and be shaped by the material world. Legal infrastructures therefore operate at multiple levels as macro-social material formations, as micro-schemes of social practice, as meso-level mechanisms for disputing affects and affordances. Yet when you look closely at the appreciation of this perspective, you will realize that the utility of law is understood differently by various communities and classes. The progression of the West in most aspects of social material world that I've alluded to makes their understanding of utility of law markedly different from an understanding of the utility of the law from an African perspective, for example. Traditional environmental regulation in Malawi exemplifies this relational infrastructure. So here, communities will blend statutory law with indigenous stewardship, creating hybrid legal orders that reflect localized notions of belonging and authority. Empirical research on environmental law shows that these hybrid systems do not simply layer statutory law atop custom. Rather, they involve ongoing negotiation and contestation between the formal and the informal, producing legal pluralism in practice. Legal pluralism, in effect, as seen both in Malawi and other indigenous contexts elsewhere, highlights how multiple legal orders coexist, interact, and the legitimacy that is being negotiated in these contexts, requiring constant management and renegotiation of jurisdiction and legitimacy. This hybridity is not unique to Malawi. It resonates with broader patterns where state and non-state legal orders are brought together through mechanisms like contractual agreements or other types of accords, each respecting the other's normative commitments. That hybrid legal infrastructures are marked by permeability, their ability to absorb, to adapt, to resist, but also accommodate top-down legal impositions. However, this permeability is not unlimited precisely because the law doesn't come about or operate in a vacuum free from power relations. The law's infrastructural qualities also stratify, distinguishing between those who can access and those who are excluded or marginalized from these infrastructures. Infrastructures, including legal ones, distribute resources, opportunities, and harms unevenly, often reflecting and reinforcing existing social hierarchies informed by historical and structural formations. The work we do here at the chair exposes the limits of relationality which becomes especially apparent in contexts like digital regulation and algorithmic governance. Here I spotlight some of the work that Nelson is already doing on data governance and data democracy. Despite claims of neutrality, algorithmic systems often replicate and entrench exclusionary logics in a fashion consistent with the dictates of global capitalism that flexes its muscles in the digital space that incorporates Africa on unequal terms. With these unequal relations, critical scholarship on algorithmic governance identifies three main responses And this is access and inclusion, transparency, and refusal. Whilst efforts to improve access and transparency seek to remedy harms, they inadvertently reinforce injustice if they fail to address the underlying power relations encoded in digital infrastructure. So data justice and abolitionist approaches call for a more transformative response, asking fundamental questions about who designs this system, whose interests are they serving, and whose belonging is encoded or erased in this architecture. This echoes broader concerns in socio-legal critique about the distributive and stratifying effects of legal infrastructures. So in sum, to view law as relational infrastructure is to recognize its constitutive role in shaping social worlds, its capacity for hybridity and adaptation, and its potential for both inclusion and exclusion. Critical engagement with legal infrastructures, whether in land tenure or digital governance, demands attention to the complex interplay of norms, materialities, and power relations that structure belonging and exclusion. And in other words, it is a call to study the law in its full flow. And this takes me to my third point. Law as relational practices. And the title of our conference. Law as relational praxis. So in material terms, the law is neither isolated from, nor is it a neutral mediator of social realities. It is produced and contested through what can be called relational praxis. This is the ongoing negotiation between legal norms and the lived experiences and practices of resistance. Critical legal scholars, especially those in the third world approaches to international law, or 12, argue that the law is deeply entangled with histories of colonialism, with its attendant dehumanization and economic exploitation. 12 critiques the supposed universality of international law, exposing how legal regimes often reinforce a racialized hierarchy of norms that privilege the global north and marginalize the global south. To give an example, migration policies that criminalize border crossings exemplify this dynamic. Such laws are not neutral or purely administrative. They enact what 12 and the critics describe as visceral violence, reducing people to illegal bodies and denying them dignity, justifying their exclusion from the plane of humanity. The framing of migrants as perpetual outsiders is rooted in colonial legacies and ongoing prioritization of national sovereignty over individual rights. As Makau Mutua and Chimney note, 12 asks us to interrogate who is granted the privilege of belonging and who is systematically excluded, revealing the deep structures of power that shape legal categories and state practices. Yet, law is also a site of contestation and potential transformation. In jurisdictions across Africa, communities have used customary land tenure systems to resist the encroachment of extractive industries and state-driven land reforms. So legal pluralism in this case enables local actors to recenter questions of belonging and authority, challenging top-down legal reforms that often exacerbate dispossession and inequality. These experiences demonstrate the power of law lies not in its rigidity, but in its permeability. Its capacity to absorb, reflect, and be reshaped by the rhythms of collective life. 12 further highlights how marginalized groups develop alternative justice mechanisms outside of the formal legal networks, especially when international law fails to protect them. To give an example, migrants, for instance, will often establish informal systems of support and negotiation to navigate exclusionary legal regimes, embodying a gradual accumulation of resistance that challenges dominant governance structures. Debeli has done some work on these informal networks by travelers from the continent, to places far and wide. This law from below approach, as described by Oreva Olakpe, foregrounds the agency of those most affected by legal exclusion, offering new models of justice rooted in local experience and collective action. So in sum, law as relational practice is not static. It is a field of struggle, a field of disruption shaped by historical legacies and contemporary power relations, as well as the creative resistance of communities. 12 compels us to recognize both violence and possibilities within legal systems, urging a continual reimagining of law as a tool for social and economic justice, rather than a simple mechanism for reinforcing exclusion and hierarchy. And this leads me to my fourth point on disruptive discourse and decolonial futures. Now, disruptive discourse is essential for dismantling entrenched hierarchies. Decolonial theory insists that transformation emerges not from incremental reform, but from unsettling dominant structures, narratives, and practices. My research on energy access interrogates how human rights language, often co-opted by technocratic and market-driven agendas, can be reclaimed as a tool of transformative justice rather than mere technical remedy. So framing energy poverty as a violation of dignity rather than as an engineering or financing problem recenters the law's ethical purpose to serve people and communities, not markets or corporations. Critical scholars argue that disruptive discourse requires more than rhetorical critique. It demands the creation of new spaces of enunciation where counter-narratives can emerge to challenge colonial binaries and hierarchies. This space is not neutral. It is a site of struggle where marginalized voices contest the terms of belonging and justice and therefore assert their humanity. Postcolonial scholars, such as Robert Young, warn, however, that the language of hybridity that these spaces of enunciation enable must be used carefully, lest it obscure ongoing inequalities or repeat the colonial logics under the guise of mutuality and gestural amplification of human agency. The colonial approaches, in my mind, must advocate for a global ethics grounded in relationality and plurality, taking seriously the lived experiences of the historically oppressed. This perspective urges us to move beyond Eurocentric frameworks and to value the epistemologies and practices of the global South. In Africa, like elsewhere in the global South, the colonial feminist and indigenous movements have developed disruptive discourses that link energy justice to broader struggles for land, autonomy, and cultural survival. These movements foreground the interconnectedness of social, ecological, and epistemic justice, challenging extractivist models that perpetuate colonial forms of dispossession. Disruption, in this context, also means that we must confront new frontiers of exclusion. Consider digital technologies, for example, which promise global connectivity, often replicate colonial logics of surveillance, commodification, and exclusion. Algorithmic governance, as critical data scholars note, can reinforce existing hierarchies by encoding bias and privileging corporate interests over community needs. The vision of a digital commons, where belonging is not contingent on data extraction or market value, requires legal and ethical innovation rooted in the colonial imperative of community emancipation over corporate capture. And embracing disruptive discourse then is not simply about critique. It is an active, ongoing process of imagining, reimagining, and enacting futures of livable worlds. This involves unsettling the boundaries of law, reclaiming its emancipatory potential, and centering the voices and struggles of those historically excluded from its protections. As the history of past struggles for emancipation reminds us, only through such disruption can we begin to build legal and social orders grounded in justice, dignity, and collective liberation. And this is why we would like to make this a focus of the next period of our research agenda. Now, I would like to make a closing argument. And this is about centering belonging as a focus of our research agenda. So legal artifacts allow us to make sense of our place in the world. Whether it is the certainty offered by something as mundane as one's Vodafone contract, or something a bit more solemn, such as the guarantee to be free from genocide, as undergirded by the Human Rights Corpus. However, this is not a given. In the words of Chimney, international law is but a site of struggle, not a gift. So let us struggle then for a world where belonging is not a privilege afforded by some at the expense of others, but rather a birthright, where law reflects the harm of shared humanity and not the silence of subjugation. To all of us here, I believe our task is to wield law both as a shield and a scaffold to protect the vulnerable, but also excise the rot of inequity. Do not seek permission to speak the truth, for the law belongs to you as much as it does to the powerful. Let me conclude with a lesson from my artistic pursuit as a teacher. And this is about writing. And so writing, like painting, requires a lot of patience, but also the courage to revise. The courage to change one's mind. Early in my career, eager to identify myself as a public international lawyer, I hesitated challenging orthodoxies. But 12 scholars, past and present, have taught me that critique is an act of love. It's an act of care. We critique not to nihilistically dismantle, but to build. And now I would like to leave you these 4 provocations that I hope, alongside you, I will grapple with in the coming months and years. So first, what if we reimagined law not as a tool of order, but as a living archive of collective struggle and resistance? Secondly, are we able to challenge the current notions, discourse, and understandings of utility of law, which has to date shaped the trajectory of legal research, particularly international law? Can we challenge these notions? Thirdly, can we build legal frameworks that center the knowledges, aspirations, and sovereignties of communities historically rendered invisible by colonial modernity? And finally, how might we disrupt the seductions of technological progress by insisting on digital and ecological futures rooted in care, reciprocity, and justice, rather than extraction and surveillance? And with this, I welcome you to this celebration of idea, and I hope that we have an awesome conference in the coming days. Thank you.